Hello everyone, this is Tom Fox and I'd like to welcome you to episode 126 of the FCPA Compliance and Ethics Report. Today I take a look at the opinion releases from 2014. There were two of them, Opinion Release 1401 and Opinion Release 1402. I take a deep dive into the facts of the opinion release and how the compliance practitioner might use them going forward. I hope you'll find these episodes this discussion interesting, and the episode comes in just over 20 minutes. Thank you. Hello everyone, this is Tom Fox and I would like to welcome you to this episode of the FCPA Compliance and Ethics Report. Today I wanted to visit with you about the two opinion releases that we received from the Department of Justice in 2014, Opinion Releases 1401 and 1402. For those of you who are not aware of what an opinion release is, it is a procedure by which a company can ask the Department of Justice questions about whether a particular transaction or set of facts might violate the FCPA, or rather whether the department would seek to prosecute the company if they engaged in the action that they proposed. It can be a useful tool for companies. There has been some amount of criticism of the opinion release procedure, that it's not utilized enough and that it takes too long. And we've had a couple in the past year which I think go a long way towards dispelling those two criticisms. So I'd like to go into each of the procedures and see what they tell us and what we might be able to glean from them and how you might be able to use this information going forward. The first one came out in March of 2014, and I found it to be very interesting. It continued the opinion release procedure process by which the department opined in a way that I would not have predicted. In other words, starting with Opinion Release 1202 and going forward through 2013 and into 2014 with 1401, if you had asked me 100 times about the fact pattern, that I would have opined it was an FCPA violation, yet the department found it was not a violation. So let me go into the facts at some length to try to explain this. The company that requests an opinion release is called a requestor. So I'll use that phrase because the company is not identified in the opinion release itself. So the requestor had purchased a foreign company in 2007 from a foreign shareholder when he was a private citizen. To guarantee the foreign shareholder's participation going forward, the parties' agreement contained a 5-year lock-in period that prohibited the foreign shareholder from selling additional interest prior to January 1 of 2012. The agreement did allow the foreign shareholder to leave the foreign company and go to work in his country's government if he were appointed to a ministerial level position or higher. This eventuality came to pass, and in December 2011, the foreign shareholder became a foreign government official as defined under the FCPA when he was appointed to serve as a high-ranking official at the foreign country's Central Monetary and Banking Agency. This agency is responsible for banking and financial regulation and monetary policy in the foreign country in question. Upon his appointment, this foreign shareholder ceased to have any role or function at the foreign company other than being a passive shareholder. Now a foreign government official desired to sell his interest in the company. However, under the formula for repurchase of his interest was valued at zero, primarily due to the financial crisis of 2008-2009. Apparently, the foreign government official threatened to sue or sell his interest to a third party, and the requester did not want either eventuality to come to pass. The parties agreed to another form of valuation and sought approval from the Department of Justice regarding how to pay the now foreign government official under this valuation. The foreign government instrumentality that this foreign government official is now a minister at does not regulate the requester, but the requester has done business and will continue to do so in the past. So it's not exactly clear of the relationship other than there's some sort of business relation. The foreign government official informed the Department of Justice that in the past he had not influenced or sought to influence the foreign country's government or any third party with respect to the entities in question, and attested that he would not do so in the future. Additionally, the requestor provided separate internal communications to the employees of the entity in question to the effect that the foreign owner was now a foreign government official and that he was prohibited from participating in any discussions, consideration, decision, or otherwise influencing any decision relating to the award of business by the foreign instrumentality to the requestor. Additionally, there were three representations which I found significant, and they were as follows. The requestor obtained a representation from the now foreign government official that he had disclosed his ownership interest to the foreign government and the proposed sale of the shares in question to the relevant government authorities of the foreign government and the relevant department at the instrumentality where he now worked, and that the government authorities he reported this to approved and did not object to the sale of these shares. The foreign shareholder had warranted in writing that any payment to him for repurchase of the shares will be made solely as consideration for the shares and not in his official capacity or in exchange for any presented or expected future action. And third, the requestor had received written assurance from local counsel in the foreign country in question that their purchase of the shares would be lawful. So they got a legal opinion from a foreign law firm. In its analysis, the Department of Justice focused on several factors. Initially, the Department of Justice noted that the commercial relationship between the requestor and the entity in question began before the individual involved here became a foreign government official. Further, even if the sales contract was not followed because under it the foreign official would not have received fair value in the buyout, the requestor presented legitimate business considerations and prompted and justified the renegotiation of the buyout formula. This justification was coupled with a new valuation which would be set by a leading, highly regarded global accounting firm to determine the shares' values, and apparently an apparent sharing of the entity's financial information with the Department of Justice occurred as well. The DOJ noted that the requestor's decision to engage the independent global accounting firm to serve as independent and binding arbiter of the value of the shares provided additional assurances that the payment reflects the fair market value of the shares rather than an attempt to overpay the foreign shareholder for a corrupt purpose. Neither the requesting company nor the foreign shareholder requested or obtained conditions or limitations on the value to the formulation which would be provided by the accounting firm, and the valuation was carried out strictly in accord with the terms of the engagement. There was no indication of either party requesting a minimum or specific value from the accounting firm or attempting to improperly influence the valuation. Equally important, I found, was the transparency involved. There was an appropriate and meaningful disclosure of the parties' relationships. There was disclosure by the foreign government official to his own government of the relationship and the pending sale. Finally, the relevant government authorities of the foreign country and the relevant department at the foreign agency involved have information and approved or did not object to the shares of the sale. Lastly, once again, when the requester and the foreign government, now foreign government official involved, attested that they would not assist the U.S. company going forward to obtaining and retaining business. For the compliance practitioner, I found that there were several key points to consider. And once again, I have to emphasize that if you had ever brought to me the question of whether or not you could change a formulation so that a foreign government official, now foreign government official, got money through a buyout clause, I would have said that violated the FCPA 100 out of 100 times. Yet here the DOJ went in a different direction. So initially, I would note the time frame involved, because this was the first time the Department of Justice really spelled this out. And in a footnote, it read that following the requester's initial submission to the department requested additional information on July 25, 2013, and on September, which was provided on September 19 of 2013. And thereafter, the department and counsel for the requester had several follow-up meetings to clarify certain issues, and on February 13 of 2014, the requester provided final submission, and less than 1 month later, the opinion release came out. So that gives you the time frame involved. Second was the use of reps and warranties by both parties. Looking back at opinion release 1301, a key component was from an opinion from the chief legal officers of the foreign country involved that the questioning conduct would not violate that country's laws. However, in 1401, the DOJ accepted representations that the foreign official in question would not pass on business in which he either had an interest or would help the relator, or the requester rather, obtain or retain business with the agency in question, which he now worked at. This type of evidence is something that a company should now consider when designing protocols to satisfy issues similar to those presented in Opinion Release 1401. Next is the quality and quantity of the payments to be made to the now foreign government official to cash him out and to purchase his interest. Here the parties agreed to an independent evaluation by an internationally recognized law firm. This provides some type of arm's length analysis. It also provides a market-based approach to the payment issue so that there is evidence of true market value and not some arbitrary number agreed to by the parties. Finally, all the parties seem to have documented everything. This clearly speaks to the need for my three most favorite words on FCPA compliance of document, 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 all of which can be reviewed by a regulator. So very interesting, very useful, and it shows you how you can work with foreign partners who may go in and out of government on a regular basis. This is obviously a problem in certain countries where there's a limited number of credentialed folks for you to either partner with on a business basis who may go in and out of government. So very useful information in 1401. 1402 came out in November of 2014, and here we had a little bit different focus because the company in question was attempting to purchase, or through mergers and acquisition activity, acquire a foreign company. And that foreign company had not previously been subject to the FCPA. And in its investigation, the U.S. company turned up some questionable payments. And so the question presented was, would this provide springing liability to the acquiring company? So let me just go into this. And 1401 really brings up another one of my favorite words in FCPA compliance, which is to dislink. And I find this adjective useful in explaining how certain conduct by a company must be separated from the winning of business. But it really works on a lot of different levels. I think we saw dislinking fairly dramatically in 1401, but in 1402 it was also present. 1402, I think, also directly answers many FCPA naysayers who have long incorrectly claimed that companies step into FCPA liability simply through mergers and acquisitions activity. First of all, it was noted that the requester was a multinational company headquartered in the United States, which desired to acquire a foreign consumer products company and its wholly owned subsidiary, both of whom were incorporated and operated outside the United States, never subjecting themselves to U.S. scrutiny via issuing securities or operating in the United States. There were no direct sales or distribution of the target's products in the United States. In the pre-acquisition due diligence, the requester identified a number of likely improper payments by the target entity to the foreign government officials of the foreign country where it was domiciled, as well as substantial weaknesses in accounting and record keeping. In light of these bribery and other concerns identified in the pre-acquisition due diligence process, the requester also detailed plan for a remedial post-acquisition measures and post-acquisition compliance integration steps. The requester sought from the Department of Justice an opinion as to whether the department would bring an FCPA enforcement action against the requester for the target's pre-acquisition conduct. And so in preparing for this acquisition, the requester undertook pretty substantive and substantial due diligence aimed at identifying both potential legal and compliance concerns by the target. The requester retained an experienced forensic accounting firm to carry out this due diligence review. The review brought to light evidence of improper payments, apparent improper payments, as well as the accounting weaknesses and poor record keeping. There were significant transactions involved with a multi-million-dollar value, which raised compliance issues. The vast majority of these transactions involve payments to government officials related to obtaining permits and licenses. However, other transactions involve gifts and donations to government officials, charitable organizations, and sponsorships, and payments to members of state-controlled media to minimize negative publicity. None of these payments violated the FCPA, however, because there was no U.S. nexus. The due diligence showed that Target had significant record-keeping deficiencies, and that the documentary evidence itself did not support the vast majority of the payments to the government officials. So we had finally, the Target had not developed or implemented a written code of conduct or compliance policies and procedures, nor did the Target's employees show an adequate understanding or awareness of anti-bribery and anti-corruption laws and regulations. The requester presented several pre-closing steps to remediate the Target's weaknesses prior to the planned closing in 2015. The requester aimed to complete the full integration of the Target into the requester's compliance and reporting structure within a year of closing. The requester also set forth an integrated schedule of the Target that included various risk mitigation steps, dissemination and training regarding to anti-corruption compliance procedures and policies, standardization of business relationships with third parties, and formalization of the Target's accounting and bookkeeping records in accordance with the U.S. company's policies and the applicable U.S. law. In its analysis, the Department of Justice began with fairly black-letter law, which quote the following: that it is a basic principle of corporate law when a company assumes liabilities when merging or acquiring another company. In this situation, where the purchaser acquires stock of a seller and integrates the Target into its operations, successor liability may be conferred upon the purchaser for the acquired entity's pre-existing criminal and civil liabilities. So, however, this is tempered by the 2012 FCPA guidance, which says successor liability alone does not create liability where none existed before. So, for example, if an issuer were to acquire a foreign company that was not previously subject to the FCPA, the mere acquisition would not retroactively create FCPA liability for the acquiring U.S. company. This means that because none of the payments were made in the U.S., none went through the U.S. banking system, and none involved a U.S. person or entity, i.e. no FCPA jurisdiction, this would not lead to the creation of liability for the acquiring company. Moreover, there would be no continuing or ongoing conduct going forward because there were no contracts or assets which were determined to have been acquired through bribery that would remain in operation or which the requestor would derive financial benefit following the acquisition. Therefore, there would be no jurisdiction to prosecute any of the entities involved afterwards. The department also provided additional information along the lines of the following. The department does encourage companies to go through a risk-based FCPA anti-corruption due diligence and to quickly implement the acquiring company's code of conduct and anti-corruption policies as quickly as is practicable. Conduct FCPA and other relevant training, conduct an FCPA audit, and disclose to the department any corrupt payments discovered through this due diligence process. 1402 clearly communicates there's no such thing as springing liability. So for those people who were concerned that simply by buying a company you're going to get FCPA liability, that's not true. But the key is really twofold. So you've got to do your due diligence going forward in your pre-acquisition phase. If you don't, and you allow the conduct to continue, that's where you're going to derive your liability. So it's pretty clear that the pre-acquisition phase is becoming equally important. The opinion release pointed out some of the techniques you can use, and these include having your internal or external legal, accounting, compliance department review a Target's sales and financial data, its customer contracts, its third-party and distributor agreements performing a risk-based analysis of the target's customer base, performing an audit of selected transactions engaged by the target, and engaging with the target's general counsel, vice president of sales, or internal audit, all about corruption risk and compliance issues going forward. So this was really the first opinion release which focused on pre-acquisition due diligence. Obviously, we've had several beginning in 2008 with the Halliburton opinion release, which focused on post-acquisition conduct. We've had enforcement actions that talked about post-acquisition conduct, but here we talked about pre-acquisition conduct. So a very useful opinion release. Hopefully this will be something that companies will take a hard look at going forward and really help direct this into their compliance regime. So very useful amount of information in the two opinion releases from 2014. These are available on the Department of Justice's public website, as are all opinion releases. I hope you'll take a look at them. If you'd like further information on them, you can contact me at tfox@tfoxlaw.com or give me a shout. Otherwise, this is Tom Fox, and thank you very much for listening.